So, welcome to Just Settled. Thank you so much. Today we have Tizoc Perez-Casillas, an incredible personal injury and employment lawyer out of downtown Los Angeles, with us here today. Thank you for joining us, Tizoc, on Just Settled.
Thank you, Dan.
Awesome. And yeah, I want to kind of dive right in here to this case that we were discussing. This is an employment law case that you had. And yeah, there's a lot of interesting kind of details to dive into. How did you first learn about this particular employment law case? What were your initial thoughts when it came across your desk, when you kind of got into all the details of it?
Yeah, when we first got the case, we knew what occurred wasn't right, but we didn't know the extent of the misconduct that occurred. So our client worked at a fast food chain in the kitchen, and every day he was called derogatory names based on his sexual orientation. So my client was a private person, so these were not things that he wanted to share or talk about with coworkers, but his supervisor allowed others to make fun of him, and he would laugh or partake in the mistreatment. Now, that's all we knew at the beginning, but we uncovered a lot of information that led us to find examples of quid pro quo sexual harassment, meaning work preferences in exchange for sexual favors, and other acts which were completely intolerable. As a sidebar, while we resolved that case, we currently have an ongoing case against the same company. So I have to be a little bit cautious about what I say, but oftentimes when a supervisor engages in harassing conduct or when a hostile work environment exists, more than one person is subjected to mistreatment in the workplace, and that's certainly what we had here. Now, there were other issues in the case. Our client was injured at work, and when he tried to go back to work, they didn't engage in an interactive process, which is required by law. So there were other issues in the case, but again, when we first uncovered it, that's what we found.
Did you have initial concerns or uncertainties about how this case might play out? What kind of outcomes you were looking at, and how did you address those concerns when you first kind of saw what some of the challenges might be?
Yeah. So, one sort of concern that we had or issue that we came upon was an arbitration agreement. So, typically nowadays, especially, employers have their employees sign an arbitration agreement, which means that employee waives their right to a jury and it's decided before an arbitrator, which is just one person. And typically the award in arbitration is lower than through verdict. So that was sort of an uncertainty that we came across, but we were able to overcome that. So what happened in this case, the defendant filed a motion to compel arbitration, and we propounded discovery regarding the context of that arbitration agreement, because it was our understanding that our client did not sign it. We had to go to an IDC, which is an informal discovery conference that some courts allow, and the court ordered defendant to allow us to depose the person who allegedly onboarded our client. And after, discovery was in effect, they withdrew their motion to compel arbitration, so we were able to proceed in court.
Okay, so yeah, and that kind of dovetails into my next question, because obviously there's some challenges that I would imagine in these cases are typical or occur frequently when you're kind of coming up against this type of thing. Was there anything specifically unique or difficult about this case that was a little bit unpredictable, or that when you first went in you may not have expected, and then as you did discovery and found things out that you kind of realized made this case different or unique from other cases?
So I guess just to kind of dovetail off the previous question, typically we do fight arbitration agreements at our firm. In fact, we won an appeal based on 1281.97 and 1281.98, which states that an employer materially breaches an arbitration agreement if they fail to pay fees within 30 days of the due date. So again, we make it a habit to fight these arbitration agreements. But another sort of challenge that stood out was, as I mentioned, our client was a private person.
Right.
And it was difficult for him to sort of express his emotions. And in these types of employment cases, especially if it's a low wage earner, the emotional distress drives the value of the cases. So we were able to pair our client up with a therapist who was able to help him explore and express some of the mistreatment that he was subjected to that he otherwise may not have been able to express. So that certainly helped.
Yeah, that's great. Um, can you describe kind of how the negotiation process unfolded in this case? Did the opposing party, this fast food restaurant, whether it was the employer or an insurance company that was insuring the business, did they attempt to minimize the compensation, and how did you kind of proactively fight for your clients on your client's behalf?
Sure. Yeah. So typically they try to minimize the compensation. So what happened in this case is I think we took a few rounds of depositions, and we had a mediation scheduled. And right before this mediation, we uncovered some tough evidence for them to swallow. And what they were offering at the initial mediation was an unfair offer in our eyes. And so of course we couldn't take it. We had to move forward. And it was, a good decision in the long run, because we were able to uncover some of that evidence to prove their wrongdoing. So, yeah, it was a good decision in the end.
Okay. And at what point in the legal proceedings did you realize a settlement was likely, as opposed to this going to court? Like, what factors influenced that decision, and just kind of how did that play out?
Yeah, at the end of the day, the client decides whether to move the case to trial or to resolve the case. So again, mediation occurred. It didn't work, so we knew we wanted to just trot on forward.
How did you, I mean, yeah, you've said some of this, but in terms of advocating for your client's interest during negotiations, what was that back and forth like with the opposing client, the party in this case?
Sure. Yeah. I mean, again, we had to fight vigorously, and we were not in a position to want to resolve the case. The only reason why we resolved the case, I think, is because we had trial the following month, and they proposed another mediation, but we weren't in a position to kick out the trial, and we wanted to move forward. So with that, I think pressure, they put fair value on the table, and we were able to make our client happy.
Okay. And what was the final outcome of the settlement? How did it positively impact your client's recovery or their situation? And how did that settlement align with their initial expectations?
Yeah. So, like a lot of my clients, they don't really know what the value of a case is worth when they walk in. Here our client had aspirations to switch careers and become a shop owner. So knowing this, we resolved the case to put him in a position to make those aspirations a reality. So he was very happy at the end of the day, and we were very happy to get him a positive result.
Okay, great. Well, thank you so much, Tizoc, for joining us here on Just Settle today and sharing the details of this case. And, again, anybody who needs any help in Los Angeles for personal injury cases, workers' employment law, anything like that, please reach out to Tizoc. They're an incredible law firm.
Appreciate that. Thank you, Dan.